earlier, weren't you? So as chief, I am directing all of our kind words to the middle school kids, also to the high school kids. Welcome. I'm sorry we didn't know you were sitting there. And that's my old stomping grounds, by the way. Okay, we're here. Is everybody ready for the estate of Barry? All right, we're starting with Mr. Moser.
May it please the court, counsel. My name is Joe Moser. I'm with the Finley Law Firm here in Des Moines, and I have the honor of representing Mercy Medical Center here in Des Moines, its healthcare providers, and Dr. Paul Grossman, a local surgeon. The issue before the court in this matter is the application of the 6-year statute of repose in a failure to disclose medical negligence case, where the plaintiff has alleged that the failure to disclose also constitutes fraudulent concealment. If the Court of Appeals reversal of the district court stands, it will effectively eliminate the application of the statute of repose in any failure to disclose case, including where the heart or the core of plaintiff's negligent failure to disclose claim is the exact same as the basis of the plaintiff's fraudulent concealment allegations. And that, Your Honor, under existing Iowa case law, cannot possibly be. In this case, the decedent plaintiff, Linda Barry, sought care at Mercy between October 1 and October 6, 2009. During that course of treatment, she alleges that Mercy and its healthcare providers failed to disclose an incidental CT finding during the course of that treatment, which revealed a mass on her kidney. In 2017, after seeking care related to a fall that occurred at home, she was diagnosed with cancer. In 2018, almost 9 years after the 2009 treatment at issue, she filed suit against Mercy and Dr. Grossman, alleging that 2009 failure to disclose. Only in response to a motion to dismiss did plaintiff move for leave to amend and assert fraudulent concealment allegations in an effort to avoid application of the statute of repose and salvage her case from dismissal. Then she alleged that Dr. Grossman was both negligent in failing to disclose the incidental CT and that same failure to disclose was the basis of her fraudulent concealment. The district court Judge Gamble at the time acknowledged in his ruling that this case may be subject to dismissal at a later date following further discovery. That discovery proceeded over the course of years and culminated in the district court's granting summary judgment as anticipated by Judge Gamble on the basis that the heart or the core of the fraudulent concealment allegations were in fact the same as the failure to disclose. Yes, Your Honor.
Have a situation where the negligence is failure to disclose and then there is a subsequent concealment of that?
You could have that situation, and I think that references to the Skadberg versus Gatley case decided by this court, which draws a distinction, an easily made distinction between the other cases, including Van Overbeek, decided by Justice Larson, and Vona versus Alexander, and Caswell versus Yost, which are really the 4 cases that are at issue here. And Skadberg versus Gatley involved a legal malpractice claim where the core allegation, the heart of the suit, was bad legal advice. That was the allegation, that there was legal advice given to the administrator of an estate who advised the lawyer advised the administrator that she should make certain payments related to life insurance and 401k and so forth out of the proceeds of the estate. She did so. She recognized that that was an error, brought it to the lawyer's attention over numerous communications over a year or so, and he remained silent. And there, the acts are separate, and the law requires both, number 1, a separate, independent, distinct act, and number 2, temporal separation. And the act there was the bad legal advice. When brought to the lawyer's attention, he remained silent in response to that, which in contrast to here, we have the failure to disclose, which allegedly occurred in that course of October 2009 treatment, but no subsequent act.
The specific acts of negligence were the October was it the first failure to disclose to Ms. Berry, as well as the failure to then include it in the letter to the GP? Are those both alleged acts of negligence, or is one? I think the Court of Appeals found that the letter to the GP and the failure to identify it in that letter was separate from the original act of failing to disclose to Ms. Berry. How do we determine when it's independent? I guess that's that's where the Court of Appeals went, and that's where we need to figure out what that line is.
Between existing law and the district court's opinion and the Court of Appeals' opinion. The Court of Appeals, I think, said that they don't view it as broadly as the district court did. And it seems that it also did not view it as broadly as this court did in Van Overbeek, or the Court of Appeals did in Vona versus Alexander, or again, this court did in Caswell versus Yost. And what we have is a single course of treatment, and there are factual considerations that apply in applying that existing law. First and foremost, on October 1st, she goes to the emergency room for treatment and is seen by a resident physician. And her allegation is that that resident, Dr. Sievert, failed to disclose it to her at that time. Now, there is
So the claims are against Dr. Grossman and against the Mercy entities, but not against the resident. What are the specific claims? Is there an overarching claim against the hospital or any of the Mercy entities? Or are those claims really just derivative and vicarious liability type claims from deriving from Dr. Grossman?
To me, Your Honor, that it's a generalized claim of failure to disclose that would derive from the course of treatment with Dr. Grossman as the primary physician.
There are discussions about, in 2004 and 2006, she was also seen at Mercy entities, and those CT scans were not disclosed either, or the showings from those CT scans were not disclosed. But are those part of her claim that the 2004 and 2006, those failure to disclose those CT scans was the negligence, and then Dr. Grossman was somehow covering up those?
Certainly, the discussion of the 2004 and 2006 scans is in the factual allegations of the petition. As part of the record before this court is the transcript of the oral argument hearing before Judge Porter at the district court level, where plaintiffs clarified that their allegation is that the liability-causing event is the October 1 treatment. That's the plaintiff's allegation, as I recall from the transcript of that discussion. Your Honor, what we have here, and going back to the factual discussion, is that first treatment with Dr. Sievert is the liability-causing event. Now, they shift gears to October 6, which they claim creates some temporal separation. It's the same treatment of the same issue of colitis, which was a parallel issue that she came in to be treated for.
You would define, so if 2 weeks later, Dr. Grossman would have seen her again and then sent a letter to her GP and again did not disclose the kidney mass, would that be enough of a separate independence between the concealment and the original liability creating negligence?
Your question correctly, Your Honor. No. The issue is, and I hate to go back to the factual distinction, but the first treatment from Dr. Grossman is that October 6th event. And she sees Dr. Grossman, and they allege he failed to disclose it. And again, that failure to disclose can, even in that letter, cannot also be the basis of fraudulent concealment, because we end up in this circular discussion, well, what's the problem with the letter? Well, it's a failure to disclose. And
I follow you there. I'm just trying to figure out, could there be a later concealment? Or is the result really that anytime the claim is failure to disclose, concealment just isn't really an issue? You can't have concealment because the claim itself is failure to disclose.
Right, and our case law states that a doctor's failure to disclose cannot be the basis for fraudulent concealment.
2 weeks later, she just happened to pick up the phone and call Dr. Grossman's office and say, I want a confirmation of what you have diagnosed me with. And once again, he didn't say anything about the mass on the kidney. Would that then be enough to get you away out of the statute of repose?
That is a fact issue that would have to be decided by a jury, but we don't have that here, Your Honor. And this case is more similar to perhaps Bona versus Alexander, which is really factually similar to this case, where a X-ray of a knee injury was performed, which revealed an incidental finding of potential cancer in that joint.
Position is if they're sort of a course of treatment over a series of days like you have here, or even something longer than a series of days, that if you're suing over a failure to disclose over that course of treatment, you can't categorize the medical negligence as one of the acts, and the thing that gets you outside of the statute of repose is one of the later things. It's all part of the treatment. Is that what you're saying?
Your Honor, because the negligence, the core of the claim, is a failure to disclose. If the failure persists, it's still the allegation of negligence and the allegation of the fraudulent concealment, and we can't have that. And I think that the distinction here is that Skadberg case, where later it's brought to the provider's or the lawyer in that case's attention, and he remains silent. That's a separate act, independent, and also temporally separate. Here, it's not a separate act. The alleged failure to disclose is the same as the alleged fraudulent concealment. Yes, Your Honor.
Us to change any of our precedent, any of the fights that were going on in Coppice or Rudolph or any of those cases, or is this just a strict application of what we've done in Van Overbeek or some of the other cases?
I'm not requesting a change in law. I think there's an opportunity for clarification to be provided by this court to provide guidance to future litigants. However, I'm just asking for an accurate application of the existing law, including Van Overbeek, Vona versus Alexander, and Caswell versus Yost, to the facts of this case. The error of the Court of Appeals is incorrectly applying existing law to the specific facts of this case. And again, Your Honor, I think that it's worth noting that the error of the Court of Appeals is not limited just to application, but to its understanding of the facts of this case. In the closing discussion of the Court of Appeals opinion, it states that there is no concurrent medical record which addresses disclosure. And I've said throughout that it's an alleged failure to disclose. The actual concurrent record, which is found at page 355 of the appendix, is Dr. Sievert's note in which he discusses that he called Mrs. Berry back to the hospital, had a discussion with her, including about the incidental finding that was identified in the official reading of the CT, but was not present in the initial oral recitation of the preliminary CT scan that he received by phone, and said that he explained it to her, she voiced understanding, and that indicates that there was disclosure here, Your Honor, and that there can be no genuine issue of material fact on.
Dispute, or didn't she dispute that she was actually told that? I mean, doesn't that, her own testimony and her daughter's testimony establish that factual?
Allegation that she and her daughter have made in this case, which I argue is a mere allegation that is directly rebutted by the actual records.
Judgment when there's a disputed question of fact, they're claiming that the note is inaccurate. Now,
Brings us back to this discussion of the statute of repose, the core issue before the case, before the court in this case. The purpose of the statute of repose discussed in the Bob McGinnis case is specifically to limit cases that are a certain length of time before the issues because of issues like failed memory, documentation, unavailability of witnesses, and so forth. And that's specifically this case, because by the time that Ms. Berry and her daughter testify in this case, It's 10 or 11 years after the alleged treatment in a brief conversation with the physician, where their memories are, I argue, flawed because the concurrent medical record made at the time 10 years prior indicates that this information was disclosed. And so, Your Honor, we ask again that, that this court affirm the district court's finding and reverse the Court of Appeals and uphold the summary judgment grant in favor of the defendants. Thank you.
I'm not sure who's going to argue. Is it Mr. Hamilton or Ms. Hamilton? Mr. Hamilton.
May it please the court, opposing counsel. I am Steve Hamilton. Molly and I are proud and humbled to represent such fine clients in this matter. The issue arose a little bit on Mr. Moser's argument about what happened, and of course, a jury argument is one thing. Mr. Moser can make his arguments at the jury trial of this matter, but this is summary judgment. What the plaintiff says, unless absolutely unfounded, is taken as true. So here are the facts, and I apologize in advance that I'm going to be fairly harsh. Because I'm going to tell you that our position is there is an initial act of negligence that was one of many acts of negligence over time committed by Mercy, and that Dr. Grossman was guilty of reckless approaching criminal conduct when he met with Ms. Berry, and the content of his letter on October 6, 2009, that he wrote while he was consulting with Linda Berry and in the presence of her daughter, Elizabeth. So the negligence is this. Linda goes to Mercy on October 1 because she's got a bellyache. And she is there on referral from an urgent care clinic. She meets with Grossman and Severett. Grossman is the supervising physician, a surgeon of 20 years, and Severett's a third-year resident. There is a CT scan ordered by Grossman. It initially appears fairly benign. Linda leaves with Elizabeth. They get partway home and get a phone call, and the statement is limited and curt. There's not, the CT scan is not normal, please come back. And their testimony, Elizabeth's testimony, is they met again with Dr. Severett, and what he did is he told her that I am writing you a prescription for Levaquan, and you need to go to a certain pharmacy because your pharmacy is not open. And she was given a discharge document that told her she had gone from constipation to colitis. So with that type of a message, that type of information, their natural conclusion is, well, my bellyache is a little more serious than they thought. I'll go get the prescription. What Dr. Grossman testifies to is, if you have a condition that I do not treat, that is not in my wheelhouse, I do absolutely nothing but refer you back to your PCP, your primary care physician. He said, I don't even have the authority to order an MRI. He said, I don't select an oncologist. I don't refer you to. Yes.
But you don't have very much time, and I appreciate and I understand the factual basis of your allegations against Mr. Grossman related to October 1. Are you also claiming that his acts of sending the letter to the GP on October 6th was an act of negligence?
My claim is that's an absolute, that is an act that you cannot get away from the fact this almost approaches deliberate concealment.
It approaches deliberate concealment, is that what you said? Go.
It is very close, Justices.
Is that distinct and independent from the act of negligence related to the reason that she was there to see him to begin with?
See him because he's a doctor, of course, and she had a medical condition. But what he does, I think I can answer your question if you'll allow me a latitude to go through this. So this, you have to understand, Linda and Elizabeth go there on the 1st. And we've all been to doctors. You get a paper to fill out. She fills it out and tells that doctor why I'm here. And the reason she is there is colitis. She goes through all of a complex and comprehensive list of all of her conditions. I won't go through because it'll blow my time. And Dr. Lopes, our consultant, says, this woman is very comprehensive in what she tells her physician that day. And when a physician reads this and says colitis, he says, red flag. Physician knows she does not know about the kidney issue. He knows it that day. So what else do we know he knows? We know.
So I want to try and help move this along. So I think the question, you can correct me if I'm wrong, Justice Oxley, what is the alleged negligence in a little teeny box? And where is the concealment in a little teeny box? We have access to all the facts and stuff. If you can help us understand, what 2 points are you referring to?
Concealment is he, Grossman and Severett, sent her home on October 1st and did not do the referral that he says he always does.
That's negligence or that's the concealment on October 1st?
That is the negligent act, because he says I always do that.
I wanted to know in a little box, which one's where's the negligence, and then where's the concealment? Are you saying they're the same thing?
Not the same thing, Your Honor.
I'm having a hard time getting it out of you. Which one's which? Tell me.
Is on October 1 and not sending and refer her to the primary care physician because he says, I'm going to do, he doesn't actually tell her that, but in the deposition he says, I don't touch these things. They're not in my wheelhouse. I refer immediately, and he didn't do that.
Facts for just a moment. So you're saying the negligence was on October 1st by not sending her to the primary care physician. All right, and now what are you saying is the concealment? What's the date and what is the concealment in a box?
It is sending this letter on October 6th, in my view, is a criminal concealment, very close to criminal conduct. And I will tell you why. He knows so many things. He knows she does not know about the kidney condition. He looks at two CT scans read by 2 different radiologists. And the October 1 says you have a mass that has gotten bigger from 2006 and 2004. The increase in size is worrisome for cystic renal cell neoplasm. In his October...
Sorry, Mr. Hamilton, does it matter that what you're calling the concealment is something that went to another physician, not to her?
Another physician, and she met with that physician in April of 2010, again with her daughter. The doctor read the letter to her. This is all on the record in the proof. And they were confident then that she was healthy because when the letter was read to her, it simply talked about her stomach issues because she knew nothing about the kidney at that point in time. She never did discover it until she fell and injured herself, and a nurse at a hospital said, you got a tumor, lady. And she says, I didn't know that.
Let's go back to the letter on 10-6. You keep saying it's criminal concealment. Your expert, Dr. Lopes, even said that that was negligent in and of itself. And that's where it seems like that you're trying to say that the failure to disclose on October 6th was itself a liability-creating act of negligence.
Would be because it concealed her condition.
For fraudulent concealment to get you past the statute of repose, there needs to be a concealment that's independent from that liability-creating act, and that's what I'm trying to find where that independence is.
Certainly, he could have corrected his conduct that day, but I'm suggesting that you cannot view this as a legitimate treatment.
That's not the point. The question is, as I see it, arguably kind of foggy, but when is an act of concealment independent of the liability causing negligence? And here we've got October 1 and October 6. It's kind of compressed. It's part of a course of conduct in some sense. And the argument then is, well, it's not an independent act. You're slicing and dicing pretty sharply. You're saying, well, October 6 is not October 1, and the letter was independent of the original negligence. I gather that's your argument, but don't you have to show that October 6th is independent of the underlying liability?
Independent, Your Honor, it's an independent. Let me just finish. I think I'm going to convince you this is almost criminal. All right, he reads.
Criminal, frankly, for purposes of this question. I might care generally about it, but for the purpose of the question, is this part of a continuing course of conduct, or is it an independent act? And if you can't tell me, I don't want to hear that it's criminal. I want to know that it's an independent act, and maybe you can make that, but I haven't heard it yet.
An independent act of concealment. Okay, he reads 2 scans. He says it in his letter because he says, to figure out your colitis got better, I read 2 scans. What do those 2 scans say? They both tell him this woman has a tumor on her kidney, and it tells him it has grown. As Loeb says, to a doctor, what that means is you have a malignancy that is going to continue to grow, and if not addressed, it's going to kill you. So he knows 2 things that day when he writes this letter. He knows she doesn't know about it. He knows it's likely going to kill her. And the third thing, he knows she's not going to find out about it when she leaves my office. So this is not a treatment, Judge. That's what I'm arguing. This ain't treatment. This is a almost deliberate concealment.
Let's go at it from this direction. I think that what needs to be independent is that he's concealing his prior negligence. I think that's why fraudulent concealment gets you past the statute of repose, is if a physician engages in an act of negligence and then hides that negligence, then you're not bound by the 6-year statute of repose because you have no way of knowing it, because he has concealed his own negligence from you. So it's not necessarily that it's an independent act, but it needs to be an independent act that hides his prior negligence. And so can you speak to how his letter on October 6th is an independent act that conceals the fact that he made an error on October 1st?
Tell her a thing about the act on November 1st, knowing she does not know about it. That is the concealment. But I also think there's a little bit more here to that. He recognizes what a huge screw-up there has been. In 2004, she was not disclosed this cancerous or potentially cancerous condition. In 2006, I believe, the next time, he's disclosing that whole series, Judge.
He was not involved in 2004 or 2006, is that correct?
His surgical group was involved in one. His surgical group was involved.
Against the surgical group based on the 2004 or 2006 act of negligence of failing to disclose?
You're asking, are we making one now?
Was that part of your claim in the district court?
This is a whole series of concealment, but primarily the most recent incident is the one he concealed, the October 1 failure to refer.
So what,
But on the 10/6, you're saying that's the date of concealment. Let's say that never happened, no letter ever. Would you agree with me that the statute of repose would kick in then?
I suspect it would, but again, she would probably never find out about it after. But I do agree, the statute of repose.
I found out, that's a question I think Justice Mansfield asked. The 10/6 letter wasn't written to her, was it?
Say again?
It was not written to your client or to?
Your primary care physician, a Dr. Nikoya.
No, Justice Waterman?
It's better than my question, but what I'm trying to get at is what would be left of the statute of repose in a where the negligence is a failure to tell the patient something. Would you ever have the statute of repose?
I think you're asking me what is classically in these cases. It says if there's a continuing failure to disclose, yes, the statute of repose applies. I agree with that. But again, reading this,
And apply here.
Sorry, why isn't that what you have here?
it conceals everything before in this letter and creates a false confidence that her physical health is acceptable.
Seems like the same thing to me. The same act of negligence repeated several times by not telling her something you should have. But you're not identifying any separate act to throw her off the trail other than she remains ignorant of the cancer.
I respectfully say, Your Honor, it certainly does throw her off the trail. It does throw her off the trail because she's never going to look at anything related to her kidney once this letter hits her doctor's office. I certainly think there's concealment.
Thank you, Justices. Justice Waterman, to directly answer your last question, if this is left to stand, there will be nothing left of the statute of repose in failure to diagnose or disclose cases. That's specifically what is before this court and why the Court of Appeals reversal of the district court is a problem and conflicts with existing law.
Question. Supposing on October 10th, this is all hypothetical, completely hypothetical, yeah. Daughter and mom come back in and just say, we want a medical review. Go, sitting with Dr. Grossman, say, we're just a little confused and we'd like to start from ground zero. What's been going on? Can you go over my health history and what I need to do? And they have this meeting and there is no disclosure of the kidney CT scan, and then a letter results from that meeting going to the primary care physician that said, well, we had your patient in here, and this is what we told her, et cetera, but does not include the kidney CT scan.
And again, that this is a hypothetical, I think that's akin to the example or the hypothetical that Justice Oxley asked earlier in my initial argument, which would make it more akin to the Skadberg versus Gatley scenario, where the issues were called or presented to the provider or the attorney in that case. And so that could create a situation where fraudulent concealment would be a fact issue for the jury. But again, that's a hypothetical, and we don't have that here. Again, I think to echo my arguments before the district court and the transcript you have there, I think plaintiff's counsel made my argument for me. He again highlights for the court and could not answer the court's questions directly asking him about the distinction between the independent acts and what is separate without again arguing in a roundabout manner that, well, yes, October 6th is Dr. Grossman's negligence. It's also his fraudulent concealment. He answered, well, your expert says that October 6th is a negligent act by Dr. Grossman. He said it certainly would be. And that again highlights for the court that it's one and the same. There is no independent act here. And yes.
Sixth letter was sent to Ms. Berry instead of to her GP. Would that make a difference?
That we come back to application of the specific facts of this case. The initial treatment on October 1, when the CT is called back, the discussion is had by a resident physician, Dr. Sievert, not with Dr. Grossman. Dr. Grossman's first time he sees her after the preliminary oral CT where this mass is identified, when the final CT comes back, is on October 6th. And so for the claim with respect to Dr. Grossman and his practice, it is one and the same. So that could be Dr. Grossman's negligence. It would also be his failure to disclose. That's not true of the first treatment because that does not involve the same providers or the same issue. It's an act without any fraudulent concealment by those actors. And so, Your Honor, I think that we've covered the basics of this, and it's that the statute of repose may be a harsh consequence, may result in litigants not being able to bring cases under certain factual scenarios, but that's a policy decision that's been made by the state that is an important distinction for important policy reasons, and it has to be given meaning. And that to uphold the Court of Appeals opinion will be to eliminate application of the statute of repose in failure to diagnose and disclose cases, and will cause problems for years to come and require litigation where those problems need not exist, because under existing law, under Van Overbeek, under Vona versus Alexander, Caswell versus Yost, and even Skadberg versus Gatley, we have an existing framework that, when applied to the specific facts of this case, requires that it be dismissed pursuant to the statute of repose as untimely and time-barred. Thank you.
The case of State of Linda Berry is hereby submitted. We will take a 5-minute recess, and the next case for oral argument is Rand versus Security National Bank. Those attorneys can go ahead and get set up.
Take care.